This letter's got to be one of the most bizarre letters that I've seen from TV licensing, and most probably unlawful. Most probably in the case that I'm going to show you, and definitively if it's for England and Wales, and I'll explain why I say that in a minute. And it's been a while since I've done a TV licensing video, so this one ought to be interesting. But first of all, if you're new to me or if you haven't subscribed yet, I'm Daniel Shensmith, a barrister of England and Wales. I'd be really grateful if you do subscribe, because I depend on you, the viewer, to do that and like the video and share it with somebody so that YouTube spreads me to a wider audience, because I depend on you to grow my channel. I'm not owned by a big media company or anything like that. It's just me. So thank you to my viewer for sending me this letter, which I'm going to go through here, because it's to do with the removal of the implied right of access. That really is a thing. Some people think it's just one of these buzzwords that doesn't really mean anything in law. It does. And just as a brief aside, and say hello to my little Christmas friend here, if you want a copy of this removal of the implied right of access document, I'm going to put that along with other things on my website, BlackBeltBarrister.com. It is a subscription service, but I'm going to put lots of different videos on there. How to bring a case as a litigant in person, how to run your case, what to do when you get documents through the post, the law on self-defense and martial arts, all sorts of other stuff is going to be included on there as well. There is already a whole bunch of stuff on there. It's only $14.99 per month. You can subscribe. I will put that in the description below. Go and sign yourself up. That will support me, and I will produce lots of different guides and how-tos and documents, and put template documents such as this removal of the implied right of access on that website. So do check that out, and I'll be grateful. Back to the video. Now, in short, you'll be a trespasser on someone's land unless you've got a lawful reason to be there. One lawful reason might be the implied right of access, such as walking up to somebody's front door, posting a letter, ringing the doorbell, and all that sort of stuff. So when you remove this implied right of access, you're telling everybody that you are no longer welcome here, you can't come here, and you'll be trespassing if you do. So on that basis, my viewer told TV licensing, do not visit my address. I've removed your implied right of access. You're not welcome here. Now, with the caveat that there is a provision under the Communications Act that they can come to your premises with a warrant, which I'm not covering in this video, but if they do have a warrant, that is completely separate. And there's a separate duty to assist them, but I've covered that in other videos. This is specifically about this implied right of access. So this letter says, thank you for your recent contact, which has been recorded under reference Blur. Please use this number if you wish to contact us again. To confirm, I've updated our records to show that you don't require a license, as you've told us that neither you nor anyone else living at the address never watch, record, download live TV on any device. I don't know how you download live TV, because, I mean, I don't watch TV, but if you're downloading it, then it's downloaded on demand. So that's not quite right either. It's either live or it's not. It's either received simultaneously or it's not. Even if it's a +1 channel or delayed, or you've got it on pause for 15 minutes or whatever, it's still live. But downloading live TV, I have a problem with that straight away. And we're not even through the first paragraph yet, but that's not the subject of this video. This includes all TV channels, pay TV services like Sky, and TV on streaming services like Amazon Prime Video, as well as everything on BBC iPlayer. Now, this is wrong in a number of respects as well, and we're still not at the point that I really want to talk about in this video, but I have to pick this up. Everything on BBC iPlayer, it says. Well, that is wrong, because I believe S4C is on iPlayer, and you do not need a TV license to be watching S4C on iPlayer. It's BBC programs on BBC iPlayer. Therefore, having iPlayer, even accessing iPlayer, is not in and of itself evidence of the commission of an offence under the Communications Act of not having a TV license, if you're watching S4C by way of example. I don't know what else is on there because I don't watch it, but if it's anything other than BBC content, you don't need a license for it. But it says this includes all TV channels, pay services like Sky, and TV on streaming services, live TV on streaming services. So yes, if it is live TV, then the rest is correct. Let's leave that alone for now. We won't be in touch now until your claim is about to expire. Now, this is about this 2-year thing when you tell them you don't need a license and then they come back every 2 years. This is not a legal thing. This is just them saying we will come back after 2 years. I can't find anything that says that there's a statutory duty or obligation or permission or whatever that they can keep bugging you every 2 years to see whether you need a license. I couldn't find that, but again, not the subject of this video. We may write, they go on, to the address again if anything changes before then. I don't know how they'd know if something changed before then, but they'll write if that happens. TV licensing do not permanently stop writing to any address. Well, that may be the case, but it may constitute harassment in certain situations, which I've also covered in previous videos. This is because something may change, which means the address may need a TV license. Well, yes, if you start to watch or record live TV, then you probably need a TV license. But again, how would they know? But maybe they've got certain records and such like, but let's move on. Watching, recording, or downloading programs without a valid license is a criminal offence. Now, hold up just a moment. If you download a program, it is not watching or recording live TV. So unless they're talking, which it doesn't specify, unless they're talking about BBC programs on iPlayer and downloading those, I don't even know if you can download those on iPlayer because I don't use it, but unless it's talking about those, that is also wrong because you can download programs on other services without needing a TV license, and it's not a criminal offence. So there's a lot to break down here, but we will get to the bit that I want to talk about in just a moment. Our letters explain what could happen if someone is caught watching, recording, or downloading live TV without a license. Again, the downloading thing. I mean, how do you download live TV? It's either live, which is being received at or around the same time as it's being broadcast to everybody else, or you don't. You're either receiving it or recording it, or you're not. You're not downloading. Anyway, if we don't receive a response, now I really take issue with this bit. If we don't receive a response, the tone of the message will become stronger. Is that evidence that anything that comes later with a strong tone may be intentionally harassment? Perhaps? Question for later on when you receive further letters with stronger language. Let's move on. You don't have to tell TV licensing of the current situation. You don't have to tell TV licensing of the current situation. But if confirmation is not received, we cannot reduce contact to people who do not need a license. So if you don't tell them, we will keep writing to you with stronger language. This is just really bizarre. We will continue inquiries until you tell us if the address needs a license. Well, remember, this was in response to him telling them that we don't need a license. I say we because when I'm talking about a client, it's a way that we've raised it. We don't need a license. So my viewer doesn't need a license. This is not legal advice, by the way. I have to mention that. But he does not need a license. This whole letter is in response to him not needing a license at this address, which he's perfectly entitled to tell them. TV licensing will visit some of these addresses to confirm that a license is not required. I don't know how you confirm that a license is not required other than having the conversation, which he's just done by telling them that he doesn't need a license. If you turn up and visit an address and say, "Excuse me, do you need a license?" and they say, "No, please leave." What else can they talk about? I really don't know. But anyway, they say they will visit some of these addresses to confirm that a license is not required. If they confirm that the license is not required, they can stop contact for a further year from the date of the visit. That's not something I find in law. That's an arbitrary duration that they come up with. Now, we're almost there. I understand that you've also requested to withdraw our implied right of access to your property. However, we're unable to accept your request. That is something of a real bone of contention here. The withdrawal of the common law right for TV licensing officers to approach your property isn't recognised under Scottish law. Thank you for contacting us. The end, it might as well say. Now, this is a real point of contention because that's not necessarily true. Now, I have to caveat here, I do not practice law in Scotland. The law of Scotland is sometimes different to the rest of the United Kingdom and certainly different very often than England and Wales. They have separate acts sometimes, and there's all sorts of things where they clash and collate and all sorts of different ambiguities. Even one that might be particularly relevant here is the Land Reform Scotland Act, 2003, I think, from memory, that does talk about access rights to countryside and things like that. So it doesn't, to my knowledge, from my memory of this, it doesn't really directly relate to the removal of the implied right of access to the front door, which I've mentioned at the outset of the video, and I will talk about here now, because this is a very old law from 1765. This talks about all sorts of stuff, but the relevant bit is at the bottom. This is a public database accessible here. It says here, this was to do with trespass and everything else. The bit in green, which you probably can't see because this always jumps around, so you can't really see it properly. If I move this about, you can probably see most of it here. Let me just move this across a little bit more. That will do. Our law holds the property of every man so sacred that no man can set his foot upon his neighbour's close without leave. That just means permission. If he does, he is a trespasser, though he does no damage at all. If he will tread upon his neighbour's ground, he must justify it by law. He must justify it by law. Now, this is one of the origins, among a couple of others, of the implied right of access to somebody's front door. And this was in the negative, obviously. If someone is on your land, your property, without permission, then you are a trespasser. Now, this has been dealt with in a couple of cases, one of which is this one here. In short, this was the respondent in this case was a police officer. The police officer was the one doing the trespassing. The police officer believed that an offence had been committed by the servants of the appellant in this case, causing an obstruction in the highway with a motor lorry, followed the lorry into the police officer followed the lorry into the garage to make inquiries as to the person responsible for the supposed obstruction. The police officer did not obtain permission before entering the garage, nor did he have a warrant authorising him to enter it. The appellant directed the respondent to leave. He said, "Get out." We'll come back to that in a minute. He asked him to leave, but he didn't. He said that he was entitled to remain on the property, and then the appellant assaulted him. It was held that even if the respondent, the police officer, had the right to enter the garage to make inquiries, he became a trespasser after he was told to leave. And he was not therefore acting in the execution of his duty, and the result was that the appellant could not be convicted of assaulting or obstructing him in the exercise of his duty because he was asked to leave. And if we skip down towards the end somewhere, I've highlighted a bit. It said here, admittedly, the officers had no warrant entitling them to search the premises. It is one thing to say that the officers were at liberty to enter the garage to make an inquiry, but it's quite a different thing to say that they're entitled to remain, when, not without emphasis, the appellant said, "Get outside. You cannot come in here without a search warrant," the appellant said. From that moment on, the court said, while the officers remained where they were, it seems to me that they were trespassers, and it's quite clear that the act which the respondent was doing immediately before the assault complained of was tantamount to putting forward a claim as a right to remain where he was. So police officer said he had a right to remain there. This guy said, "No, get out." And the court said that from that point on, the officer was trespassing. And so this removal of the implied right, there's nothing to say that this can't be done in advance and say, you are not welcome on my property. You are not welcome to come onto my property to press the doorbell, which is the implied right of access, because the mere fact you have a doorbell there is implying that somebody can walk up to your front door and press the doorbell, put something through the letterbox, etc. Even the fact that you have a door there, this implied right of access exists until it's removed. Now, this letter claiming that it's been that it's not recognised under Scottish law, it is something that I'll look into a little bit further. But on the face of it, I don't accept that that's necessarily absolutely true, because the nuances of this trespass law are different in Scotland than England and Wales, but I don't think it goes that far. Certainly, if that was in England and Wales, this letter would be unlawful. This is not to be taken as legal advice. This is just my commentary on it. That would be unlawful because for the cases that I've mentioned, they are still good law unless and until they are overruled or there's legislation that steps in the way. Now, as I mentioned as the caveat much earlier on in the Communications Act, if they have a warrant, and that would require them to go to a court with sufficient evidence to provide that they're likely to find evidence of the commission of an offence on the property, and there's all sorts of things that they have to do, which I've covered in other videos. Unless they have that warrant, they cannot come onto your property without your permission. You do not have to talk to them, you do not have to answer their questions, you do not have to answer the door, and you can remove the implied right of access to your property. And so all of that combined, I think this is a really bizarre letter. not least of which because of the wording here. I've talked in previous videos how these letters may amount to harassment if they are unreasonable to the point that a person of a reasonable firmness should not be expected to bear. And it says here, it admittedly says, if we don't receive a response, the tone will become stronger. Solicitors would be criticised for language like that. Solicitors would be criticised for saying, if you don't respond to us, we'll be more aggressive in the tone of the letters that we send out. The language will become stronger. The tone of the message will become stronger. Solicitors will probably be criticised for that because courts don't generally like that approach. Courts do prefer a much more professional and approachable tone in their letters and not be unnecessarily aggressive. And again, I've dealt with that in previous videos. I've done a video on harassment before where I believe that the tone of certain letters from TV licensing could amount to harassment. And there is case law where the solicitor's letters amounted to harassment. And I compare and contrast those. I'll find it and I'll link that in the description below. Go and watch that one as well. That is a very interesting situation as well. But if you found this in any way useful, entertaining, or informative in any way, please do like the video, share it with somebody, subscribe to the channel if you're not. Even if you thought you are, please check, because YouTube has this thing of unsubscribing people, I think, to test whether you notice and resubscribe, and I think they're always testing how much that matters. Now, as another aside, completely as an aside and a background communication between me and you, this is a conversation now. Some people say, and by some people I mean some accounts that sort of teach you how to do YouTube, say subscriber numbers don't matter. They absolutely do. They really, really do. As my subscriber number has gone up, my reach has been broader, my videos get more views compared to when I was a small channel. I have published videos almost every single day, not every single day, but almost every single day for, it will be 5 years come about April next year. So almost every single day, thousands of them in the library. Go and check them out. If you want any more information on how I run my businesses, how I grow my channels, check out my personal channel, Daniel Shansmith, link below. My personal views and opinions on these things that I try not to share here on this channel all too readily. Check out Black Belt Secrets, link below. And I will be grateful to you subscribing to those. I really enjoy doing these videos. I hope you found that interesting and entertaining. And as always, thank you for watching.